So first, Professor Wuerth.
Thank you, Kurt, and thanks to everyone who came at 8:15 in the morning. It's an early time to start a panel, so I know all of us on the panel appreciate your efforts to get here. My remarks will focus, as Kurt suggested, on the relationship between the constitutional power of the president, particularly as commander-in-chief, on the one hand, and international law on the other. And more specifically, we might want to think some about what role courts do and should play in effectuating or mapping out this relationship. Now, one aspect of this question, of course, is the president's power to violate international law, either treaties or custom-based. And debates around the so-called torture memos, I think, have focused all of us on this question because some of those memos suggested, at least, that the president, when acting as commander-in-chief, was not bound by domestic law or treaties. And that has been the focus of a large amount of commentary. But there are also a number of ways in which the constitutional power of the president during wartime is related to or a function of international law that are analytically distinct from this question of whether the president is bound by customary international law or treaties, or more specifically from whether the courts should bind the president to customary international law or treaties. And I want to talk about two ways in which this is true, that is, two functions of international law, aside from the question of whether the president is formally bound. One, courts often construe presidential power over foreign affairs and in times of war in light of congressional authorization. Now, we all know this principle from Youngstown, but it's actually it's a far more durable and robust principle than the Youngstown case alone. When you go back to the framing and you move forward, cases like Brown, or early in our history, to famous cases like Quirin, and most recently to the Hamdi case, congressional authorization plays a critical role, at least in how the courts evaluate how it will approach the president's actions during war. As the most recent example, if you take the Hamdi case, all 9 justices, as different as they were in their approaches, relied upon congressional authorization as critical to the outcome of that case. This focus on congressional authorization, in turn, I think makes the tools that we use to interpret the scope of that authorization very, very important to understanding how the courts will approach the war powers of the president. And in my view, courts do and should use international law in their approach to authorizations for the use of force and to specific statutes. And this is true in 2 main ways. First of all, Congress can often, and often does, specifically rely on the law of war in enacting statutes. Ex parte Quirin is an example. That case has a lot of discussion of the law of war, made relevant for the most part in that case because in enacting the Articles of War, Congress chose to use the term law of war. That congressional authorization then became the main interpretive vehicle in terms of how the court approached the president's powers. Courts also look at international law to construe the scope of authorization provided by Congress, even when Congress hasn't specifically referenced the law of war. And again, here Hamdi provides an example. The plurality opinion in Hamdi in construing the scope of a general authorization for the use of force. If you recall, that authorization did not speak to detentions at all. It authorized the president to use all necessary and appropriate force. So when forced to construe the scope of that authorization with respect to detentions, the plurality appeared to reason that when the president's actions were consistent with international law, both custom and treaty-based, that the plurality more readily found congressional authorization. And where the president's actions arguably violated the treaties, as the plurality used, the plurality was hesitant to find congressional authorization. I think this approach to authorizations for the use of force finds at least some support in tools of statutory interpretation, most famously, of course, the charming Betsy canon, pursuant to which courts avoid interpreting statutes in a way that violates international law. Now, particularly where the executive branch has pledged to uphold international law, and particularly where international law takes the form of treaties, as is the case with respect to the Geneva Conventions, I think it's fair to conclude that Congress would not intend a general authorization for the use of force to empower the president to violate international law. I think this is an interpretive principle that's consistent with the presumed intentions of Congress, and also one that in many respects promotes several separation of powers values. In this context, international law, of course, is playing a sub-constitutional role, but as I've suggested, one that I think is closely linked to how the courts actually construe the power of the president. International law can also serve as one tool of constitutional interpretation in determining the scope of the commander-in-chief power. Of course, international law is a hotly contested issue in constitutional interpretation in a variety of contexts, and no doubt that will be true here as well. This context is an interesting one because the players have lined up a little bit differently than we see in other areas of constitutional interpretation. That is, the government has advanced consistency with the law of war as one way of construing a broad ambit for the commander-in-chief power. And you will see elements, it's quite explicit in the government's briefing in the Hamdi case, but you will also see elements of this in the Fourth Circuit's opinion in Hamdi, and some of it in the Supreme Court's opinion, at least arguably in the Supreme Court's opinion as well. There are other historical examples. It's possible to read the prize cases in this light, and there are other examples, particularly from the Civil War as well. I also think, aside from descriptively, normatively, there are some good reasons to think about international law as one tool of constitutional interpretation with respect to the commander-in-chief power. The commander-in-chief power is a very difficult little nook and cranny of the Constitution, and claims about the president's power as commander-in-chief are often suffused with language about necessity, custom, tradition. These are very, very difficult for the courts to evaluate, in my view. And it's easy for those terms to slide quickly into simple bid for deference to the executive branch. That is, it's the executive branch that best knows necessity. It's the executive branch that best understands history and tradition. I think that international law provides one metric against which to measure some claims that the executive branch might make in that context. Now, let me be clear, in neither the statutory nor the constitutional context am I suggesting that international law should always serve as an appropriate tool of interpretation, nor that it's necessarily in any particular context the best tool of interpretation. But I think in some contexts, in some situations, it can serve a very important interpretive function in both contexts. Okay. So in those two foregoing situations, when we're looking at the statutory authorization provided by Congress or a general authorization for the use of force, and in the constitutional context, international law has an important interpretive, what we might call an interpretive function, and avoids a straight-up conflict between executive power on the one hand and international law on the other. And to frame the question largely or exclusively as the president's power to violate international law, I think misses some of the ways in which the constitutional power on the one hand and international law on the other are related. I want to say a few things, though, about the president's power to violate treaties and customary international law, particularly with respect to the court's role. Now, I know that my co-panelists have a lot of interesting things to say on both points. I want to frame a couple of issues, though. The president's power to violate treaties, to my mind, implicates at least the take care clause of the Constitution, the structure of the Constitution, which puts lawmaking authority with Congress, and at least arguably puts the president's actions in Youngstown Category 3. Now, the president's power to act in these circumstances, that is, to act contrary to a treaty, I think is most plausibly a function of some core executive authority beyond the reach of Congress. That is, like the off-cited power as commander-in-chief to direct troops on the battlefield. Separating out Article I and Article II powers around the conduct of war is in many circumstances an extraordinarily difficult task. For once, the Constitution has blessed us with a fair amount of text on this question. The difficult problem is it's text that's difficult to make use of. And what I mean is there is a fair amount of text in Article 1 and 2 about the war powers, at least at the time of the framing, letters of marque and reprisal, define and punish offenses against the law of nations. It's difficult, however, to translate some of that text into modern terms. We have very little case law to guide us on separating out Article 1 and Article 2 powers related to the conduct of war. And both of these points, I think, bring us back, push the courts back to using congressional authorization as a key barometer, as a key metric of the president's war powers. Because when you find congressional authorization, as the court tends to do, it helps you avoid questions about what the president can do in the face of Congress. So at least from the court's perspective, I think it's unlikely. We have not seen to date in our case law a clear division of authority between Article 1 and Article 2. I think it's we may see more of that given the kinds of cases that are arising, but there are a number of doctrines that tend to isolate, I think, the courts from some of these most pressing questions. Standing, for example, is often invoked, the political question doctrine, and others will keep the courts from fighting kind of the nitty-gritty of this Article 1, Article 2 distinction. Finally, I want to say something quickly with respect to customary international law and the role of courts, and then turn it over to my fellow panelists. Similarly, with respect to customary international law, whatever we may think of customary international law, personally, I think it's unlikely that the courts will hold the president to customary international law as a binding rule of decision norm. I think that the real heavy lifting that customary international law can do is in the interpretive context. That is, it may have some force in how we, for reasons I've already given, in interpreting the actual scope of the president's constitutional power, or to help us understand what Congress meant when Congress says things like necessary and appropriate force. One last word on the courts. There's an enormous amount of pressure, I think, on the courts in some circumstances to recognize or acknowledge what I at least hold true, which is we want the president as commander-in-chief to take decisive military action when he sees fit to respond to national security crises as he deems necessary. That's a distinct question, in my view, from how the courts should approach the president's war powers. That is, the simple notion that the president must act with dispatch, the president must act with secrecy, is not, to my mind, the same thing as saying that the courts must automatically sanction the president's actions when appropriate cases come before the courts. And one example that I think is illustrative is General Jackson at the tail end of War of 1812, when he's down in New Orleans, hasn't received official word of the Treaty of Ghent, and there he is having having won one of the most incredible military battles in American history, and he's faced with dissent within New Orleans itself. He deals with it by imprisoning several people, including a federal judge who had the audacity to issue a writ of habeas corpus. When the war's over, he's hauled before the court, and he loses. He attempts to justify his actions based on military necessity, and the court holds against him. And I think this is a telling example, and that doesn't mean that the next time that courts should find for executive authority. What I think it means is that the president and the people who work for him can sometimes act in the face of judicial decisions or law to the contrary. What changes, though, are the political stakes. That is, when the president acts and he seeks judicial sanction for what he has done, that, I think, eases the political cost to the president substantially, which is a point that President Madison made with respect to General Jackson as well. All right, with that, I will turn it over to my fellow panelists, and I very much look forward to their remarks and to your questions as well.
Thank you. Thank you, Kurt. Let me likewise thank everyone for being here at this hour. Kurt was able to, excuse me, explain that everybody else on this panel, other than me, is someone who is a specialist and has worked extensively, specifically in areas related to foreign affairs. I'm not. My area has to do with constitutional structure, not specifically foreign affairs, but constitutional structure. So I'm going to engage in a little bit of intellectual imperialism and borrow an image from foreign affairs, that of imperialism, and try to fit the questions we're talking about, the relationship between the president and international law, and in particular the treaties, try to fit that into the larger structure of presidential power as it interacts with various forms of law. And the question I want to start with is, what are the sources of duties that apply to the president? And here, when I refer to the president, I'm going to mean the entire federal executive branch. And in that respect, I'm going to be a presidential imperialist and assume, at least for these purposes, what's called a unitary executive. So I'll talk about the president. That means everybody. What are the sources of law that give him obligations? There are various kinds of legal relations, of course. There are other sources of law that give the president powers. But I want to talk about those that impose obligations, that impose duties on the president. And there are two primary kinds of duties that the president and the rest of the executive branch can have. Those are the kind of duties that they share in general with other people, the duties primarily to respect private rights. And so, for example, the obligation of the president and the executive branch to respect the private rights of the steel companies in their private property in Youngstown Sheet and Tube is that kind of right. And routinely, the executive branch in its ordinary operations must respect private rights. A large part of the Fourth Amendment is about making sure that private rights are respected. On the other hand, the obligation to respect private rights that generally lies on the executive is not exactly the same as that lies on ordinary private people. The executive, being the government, has certain privileges under certain circumstances to violate private rights that ordinary people do not have. The sources of those privileges are primarily, as usual, statutory and constitutional. The president's statutory authority, sometimes implicitly, sometimes explicitly, authorizes him to act inconsistently with what would otherwise be private rights, as, for example, by authorizing a search or seizure that's otherwise inconsistent with the rights of private property. And, of course, the president likewise has powers that come from the Constitution that are not rooted in statute, that can be used under limited circumstances to override private rights. The president even apparently has some legislative-type powers to change people's private rights. Normally, we don't think of the president as legislating, but occasionally it happens. A classic case of this in the foreign affairs area is the United States against Pink, in which, pursuant to an executive agreement, the president settled the claims and once again altered private rights. So by identifying this area, by saying that there is a general obligation to act consistently with private rights, but there are certain privileges that make it possible for the executive not to do so. I don't mean to answer all of the difficult questions that arise there, and I'm repeatedly going to not answer the difficult questions. Rather, I want to identify a standard configuration that we are already familiar with and say that often it will carry over into the foreign affairs area. The other source of duties for the president and the executive branch is unique to the president and the executive branch, And this is the relationship between the executive and the law that comes from the obligation of the executive to carry out the law. The constitutional source of this obligation is, of course, the Take Care Clause, the president's obligation to take care that the law be faithfully executed. Ordinary people do not have this relationship with the law. Ordinary people do not have the obligation to have roads built, to have government money spent, to have criminals arrested. That lies specifically with the executive branch of government. Congress, because it can pass statutes, can impose extensive obligations that then arise under the Take Care Clause on the president and the executive branch. It's also true, and Ingrid talked about this briefly, that there are probably some constitutional limitations on the obligations that Congress, when acting through a statute, can impose on the president through the Take Care Clause. No one knows exactly what they are. This is an ongoing matter of the confusion. For example, many people would tell you that there is some constitutional minimum of prosecutorial discretion that the president enjoys. And even if Congress in the criminal statutes purports to limit that discretion, at some point it has to cease doing so. At some point, the president's possession of the executive power means that the power, as they sometimes say in the executive branch of Congress, to micromanage what the government is doing is limited. Exactly where those limits arise is a difficult question, so once again, I'm going to point to the problem rather than to resolve it. So those are the two kinds of duties that the executive branch can have. And my first large observation that has to do with our specific topic is that a treaty can impose either kind of obligation. Treaties can, and sometimes do, create private rights that then must be respected by the executive, subject to all of the qualifications that I gave you a few moments ago about ordinary private rights. Similarly, a treaty, given its status under Article 6, can impose a take-care obligation on the president, just as a statute can, and subject to the various qualifications that can be quite fuzzy about the extent to which any subconstitutional source of law can impose limitations on the president. But what a statute can do, a treaty can do, that is the logic of their being equated under Article 6. The interesting thing about treaties, of course, and this is what is known as non-self-execution, or sometimes dualism in American law, is that treaties are two things at once. They are both, to some extent, U.S. domestic law, and they are international agreements. They are bargains between states. As a result, they produce two different kinds of legal results. They produce legal results under international law that rest on the United States, and they do, or can, produce U.S. domestic law consequences. The great thing about treaties for U.S. domestic law purposes, though, is whether any particular treaty has U.S. domestic law consequences, whether it creates private rights or imposes a take-care clause type obligation on the president, is a question concerning the content of the treaty. And since there is such a thing as a non-self-executing treaty, an almost logically necessary category, a treaty could always say this treaty has only international law consequences. Since there is such a thing as a non-self-executing treaty, the question always arises with respect to any particular treaty, whether it is such as to impose either of the kind of obligation on the president. I want to suggest two grounds before thinking that one must ask carefully with respect to any treaty, whether it imposes either kind of obligation on the president. One has to do with a sometimes neglected feature of the lawmaking process by which treaties are generated. And that process differs from the statutory process in the following sense. The president has an absolute veto on treaties. A treaty can't be made without the president's consent. A law can be passed over the president's veto. The Senate can't, by 3/4 vote, sort of a super 2/3 vote, adopt a treaty without the president's participation. So one reason to think that treaties may be less intrusive, as a general matter, less intrusive into presidential authority than statutes may be, is the president's absolute veto. The other thing to bear in mind in interpreting a treaty is that automatic U.S. domestic law consequences, the self-execution, is an important bargaining chip that the United States has in negotiating with other countries. And therefore, whether that bargaining chip has been given by the United States, doesn't have to give it. Whether it's been given is a question in the interpretation of the treaty that has to be evaluated in light of whatever the bargaining dynamic and the actual bargain that seems to have been struck between the United States and the other parties. But it's important to bear in mind that that is a goodie that the United States may well want to have reserved because it didn't get enough back in return. That was about what I just said was about the U.S. domestic law, the consequences of treaties. Now, of course, treaties almost invariably, and perhaps invariably, have international law consequences. They create various kind of international legal positions before the United States. So the next question I want to say something about briefly, and this may be the most interesting of all. What are the consequences for the president under either the take care clause or his ordinary obligation to abide by the law in general, by private rights? What are the obligations for the president of the international law obligations that treaties or customary international law create for the United States? And I am going to say that I do not believe that the president is bound by the international law aspect of treaties the way he is bound by the domestic law aspect of treaties. The reasoning to that conclusion is in two parts. The first part is that, and this follows the Curtis Wright case's way of thinking about the United States' relationship to international law or the law of nations. And it takes quite seriously the notion that international law is law that governs states, that states stand in the relationship to international law, that individuals stand in the relationship, that they have the same relationship to international law that individuals have to the ordinary law. And individuals, including law-abiding individuals, can always decide to violate the law. They retain that autonomy, and law-abiding individuals generally follow the law, but they don't always, and sometimes they don't do so for perfectly good reasons. Sometimes they believe that the law requires them to do something immoral, and instead of complying with the law, they are going to violate it. It seems to me that if you take seriously that way of thinking about international law, it's extremely difficult to believe that the Constitution requires the United States always to be a law-abiding international citizen, especially if you think in historical context. Think of the United States, the new republic, in a world in which the law of nations was made by monarchies. Would it have been wise for the Constitution of the United States to impose on this new and different form of government, the Novus Ordo Seclorum, an obligation to comply with legal rules that were not necessarily made in the interests of the form of government that the United States had taken? I don't think so. Rather, the United States, like an individual with respect to the law, gets to decide whether to comply with it. Now, that's the United States as a whole. The question then for U.S. domestic law purposes is, how is the authority to decide whether the United States is going to comply with international law allocated among the branches of the United States government? One of the great things about the U.S. government is that it is externally single. It is internally divided. It has three branches, even though there is only one United States. And it's easy to think that, well, maybe this power is completely with Congress, but I don't think so, for two reasons, one conceptual and one more particular. The conceptual reason is if you think about the allocation of authority between executive power generally and legislative power generally, executive power is the operational authority, the ability to decide what to do in particular cases, to carry out broader mandates, and the legislative power is the power to make those broader mandates, the power to alter legal positions. And frequently the question, is the United States going to comply with an international law obligation? Is the United States going to extradite someone pursuant to a treaty if that extradition could have grave consequences against natural justice? Those questions will be operational rather than a broad spectrum and naturally allocated to the executive power rather than to the legislative power. More specifically, if you look at the specific allocation of authorities to Congress, Congress doesn't have a general foreign affairs power. Congress has a series of much more particular powers. They will mean that there are circumstances under which it is Congress and not the president that gets to decide whether the United States is going to comply with its international law obligations, but they will not always mean that. Sometimes that authority will be in the president. I would say that the way to understand then the pass-through of international law and the obligations it creates to the internal actors, the president and Congress and sometimes the courts, is to pursue the analogy between states under international law and individuals under the ordinary law. Say for a generally law-abiding individual, the fact that something is legally obligatory provides a reason for acting. That is a reason to do something. There is a general obligation to follow the law, but the obligation, most people think, is defeasible. And there are circumstances under which other considerations, primarily moral considerations, would lead an individual not to comply with the ordinary law. Similarly, I think the international law obligations of the United States create a reason for acting for whoever is the relevant domestic legal actor, be it the president, the Congress, sometimes the courts, but create a reason for acting that in turn is defeasible and is not absolutely binding. I would also have something to say about customary international law and all this, but I think I'm about at the end of my time and indeed maybe past it. So I will save that. Thank you.
Jinks.
So I'm going to pick up the discussion more or less where John left it. I want to start with two assumptions that will structure the remainder of my remarks. First, I want to assume that international law is in many instances in the interests of the United States. That is to say, to comply with international law is in many cases coincident with the interests of the United States. More fundamentally, and this is sort of a derived point, it may well be in the interest of the United States to have a particular domain of world politics legalized. That is to say, not simply that there is a general coincidence of interest in the sense that the rule tracks U.S. policy, but in a much more fundamental way, the U.S. might have in its interest the idea that certain kinds of rules ought to be established, even if the specific content of the rule will deviate from time to time from U.S. interests in a specific case. Second assumption I want to make is that the U.S. has the power, as an essential attribute of sovereignty, to violate international law. This is building on the point that John raised, that is to say, perhaps only as a matter of domestic law, that is to say, violation of international law through the assertion of an essential attribute of sovereignty does not relieve the United States of any international legal obligation. But it may well be that as a matter of domestic law, domestic institutions ought to understand that the United States as a whole has the capacity to decide in any particular case whether or not the U.S. ought to contravene its treaty obligations, whether or not the United States ought to withhold performance of its treaty obligations, or indeed whether the United States ought to terminate its participation in an international organization, even in a way that's inconsistent with the termination or suspension clauses provided in the specific international institution in question. My point here is that the U.S. has the ability to violate international law, at least as a matter of domestic law. The more interesting question, as John put it, is how ought we to think of the allocation of the power to violate international law? What institution in the United States has the capacity to decide the circumstances in which the U.S. Will contravene, suspend, or terminate its obligations under international law? And I don't want to dwell on the constitutional questions. I think that those issues have been raised, they've been identified, and sort of to get to the bottom of those issues is sufficiently complex that we cannot expect to arrive at any sort of sound conclusions in such a short discussion. There are take care clause problems. There's a problem with identifying a general emergency power with the president. There's a difficulty in deciding that the president has the power to make law that supersedes other prior validly enacted laws of the United States within the meaning of the Supremacy Clause. The commander-in-chief power, even if important in this equation, is not sort of a deal breaker in the sense that war powers are clearly shared. The Congress has the power to make rules and regulations for the government of the armed forces. The Congress has the power to define and punish offenses against the laws of nations. Congress has the power to make rules governing captures on land. The important point here simply is that Congress has the power, substantial power, to legislate in areas that have direct implications for the president's power to wage war successfully. Indeed, the Congress has the power to regulate in areas that impinge directly on the kinds of activities that the president could contemplate as an operational matter in executing a war. There are tremendous constitutional difficulties in deciding which of these two institutions ought to be assigned the general power to violate international law on behalf of the United States. Rather than focus on these questions, I want to focus on a few policy points. I think a couple of policy points, in fact, strongly suggest that at least our default understanding ought to be that the Congress is the institution with the authority to decide whether or not the United States should violate international law with respect to any specific treaty obligation or indeed with respect to any general case, such as a war, for example. A couple of problems I want to point to. First major problem is that assigning the president the unilateral authority to violate international law on behalf of the United States diminishes the ability of the United States to make credible commitments on the international plane. It's important to understand this point, it's important to understand the character of international law and the central kind of problem that international law seeks to overcome. So as I said at the outset, I'm going to assume that international law is in some circumstances in the interest of the United States. Let's assume that states can reap some benefits from cooperating in a particular area or coordinating their actions in a particular area. The laws of war present an example. Let's imagine that the states that comprise the international community can reap substantial benefits if they can coordinate their understanding of what is acceptable in the conduct of war, or that indeed they could diminish, perhaps even eliminate, unnecessary suffering in war if they cooperated on the content of rules. In the abstract, we have a collective action problem that's fairly easy to understand. The difficulty of solving that collective action problem and using law as a device to solve that collective action problem is that on the international plane, there is no general centralized enforcement body. That is to say, most international law cannot be enforced in the regular way that domestic law can be enforced. As a consequence, the central problem on the international plane for a state seeking to capture the cooperative or coordinative benefits of some body of international law, central problem is, how do you make credible commitments? How do you signal credibly to your would-be treaty partners that you intend to observe in good faith the obligations embodied in the treaty? It's an incredibly difficult problem. Political scientists working in the area have identified a number of devices that might be used to preserve some capacity for law to solve, at least partially, these collective action problems. One of these devices is the institutionalized participation of legislatures in the treaty process. That is to say, involving the legislature, perhaps in the process of drafting a treaty, but at a minimum in the process of ratifying a treaty or implementing a treaty, increases the credibility of international commitments, and as a consequence constitutes an important signal to our would-be treaty partners that there is a strong commitment domestically to observing the rules, and perhaps that there is a strong commitment to blocking any attempt to violate the rules. So the United States, through the Article II treaty process, has a mechanism by which the participation of the legislature in the making of international agreements is institutionalized. Now, that's not to say that the treaty process is the only means of making international law within the U.S. system. Indeed, it is not. Congressional executive agreements provide an option. Sole executive agreements provide an option, both of which may well serve the interests of the United States in the abstract with respect to a specific issue area. My point here is not to suggest that it's a bad idea to enter into sole executive agreements or that it's a bad idea to enter into congressional executive agreements. My point is preserving the option of institutionalized legislative participation preserves for the President, for the United States as a whole, one way in which international law might be made that sends a specific kind of signal to our would-be treaty partners. It's the kind of international agreement that we take seriously in a way that complicates not only the implementation of the agreement, which once implementation takes place will send a separate signal, but also frustrates any would-be attempts of the executive to violate international law opportunistically with respect to some specific case in the future. Note that all the arguments that are typically marshaled for assigning the authority to violate the law with the President counsel against assigning the authority to the President with respect to the credible commitments argument. That is to say, I can agree with the point, and indeed I do agree with the point, that the President is, as an institutional matter, better situated to act with dispatch, better situated to act with secrecy, better situated perhaps to make operational decisions with respect to a specific case. But all of those points only suggest that the President is in a better position to violate international law through a process with lower transaction costs than we would face were we to assign that authority to the Congress. But it may well be that in the interest of preserving this mechanism of creating a credible commitment, that we in fact want to elevate to the degree possible the transaction costs associated with violating international law. The President may well have within his authority the power to conclude bilateral sole executive agreements that mirror in almost every respect the Geneva Conventions. In fact, status of force agreements incorporate important aspects of the same kinds of regulatory issues, and in fact, the substance in some respects, of some aspects of the Geneva Conventions. Clearly, the President, acting under his commander-in-chief power, could, in some substantial way, replicate the body of law that we know as the laws of war within the framework of a sole executive agreement, leaving Congress out of the equation. Now, in that circumstance, there would be a strong claim that the President has the unilateral authority to violate those sole executive agreements, at least within the frame of this policy argument, because the United States, the institution in the United States assigned with the authority to conclude that kind of agreement, the President, would have decided that it's in the interest of the United States to violate that rule. But if instead the institutions assigned with the authority of concluding international agreements decide that the treaty process under Article 2 is the most appropriate means to conclude an agreement in a particular issue area, then we ought to preserve at least what I consider to be a non-trivial virtue of that process, which is it provides the United States with one device by which it can make credible commitments, signaling to its treaty partners its willingness to, in fact, its institutional commitment to observe those rules in good faith. Second policy point I want to make is that international law itself provides a device, provides multiple devices, by which states might avoid some of the more sort of sharp-edged consequences of assigning to the Congress the general authority to violate international law, at least as a default matter. What devices do I have in mind? Well, states naturally can negotiate around many of the problems that have been identified in connection with performance of the Geneva Conventions and the Global War on Terror, for example. So it could be that in law of war treaties, the United States fights for and negotiates a sort of very permissive termination or suspension clause. If the President seeks to terminate a treaty in accordance with express treaty terms, or seeks to suspend U.S. treaty obligations in accordance with treaty terms, this neither raises the policy problems that I've identified, and indeed I think that it doesn't raise the constitutional problems that have been mentioned by prior presenters. The point here is essentially that the U.S. can, through the process of negotiating international law, use various devices, whether it be suspension clauses, termination clauses, or even negotiation of clauses that allow for broad reservations, understandings, and declarations entered on behalf of the United States. The U.S. can, through the negotiation process, assure that the President has the ability to decide in specific cases that he ought to have the power to violate international law. Final point here. Assigning to the Congress as a default the general authority to violate international law also makes sense because the Congress, in turn, has the capacity to assign to the President, to delegate to the President, the authority to violate international law or withhold performance of U.S. obligations under international law with respect to particular provisions of a treaty, or even perhaps with respect to an entire treaty. This is an important point because if, in fact, Congress is assigned the authority to violate international law, and Congress decides to delegate some aspect of that authority to the President with respect to a particular issue or with respect to a particular treaty, we might capture in some significant way the cooperation and coordination benefits that I identified at the outset of my talk, but at the same time preserve the capacity of the United States to act with dispatch, to act with secrecy, to act in a way that the executive, frankly, is well positioned institutionally to act. The bottom line of my comments is essentially that even if we think that the United States ought to have the power, as a matter of domestic law at a minimum, to violate its international treaty obligations in some circumstances, that leaves open the question, who ought to have the power to decide when the United States should do so? I think given the nature of international law, given the nature of the relationship between the Congress and the President, and given the various institutional features of the two branches of government, it makes sense to assign, at least as a general matter, that authority to the Congress, at least with respect to treaties that have been concluded under Article 2. Thank you.
Michael Ramsey.
All right, I wanted to turn to the question of customary international law and its relationship to the president, and specifically ask the question, does customary international law bind the president as a constitutional matter? Of course, it binds the president as a matter of international law, but does it bind the president as a constitutional matter? And I wanted to address that question specifically in terms of the text and original understanding of the Constitution. And I wanted to note that this question, among others, was specifically addressed by the so-called torture memos, which concluded that customary international law did not bind the president as a constitutional matter. I want to argue that that conclusion was wrong, although I think that the correct answer is not so far from that conclusion as it might appear at first. So let me begin with a couple of starting points. First of all, the president is bound by treaties through a combination of Article 6, which says that treaties are the supreme law of the land, and Article 2, Section 3, which says the president must take care that the laws are faithfully executed. There are, of course, some exceptions to this, as some of the prior panelists have noted, but as a general matter, I shall assume rather than defend that proposition. Second, customary international law, as a general proposition, is not part of the Supremacy Clause of Article 6 because customary law is neither a treaty nor is it law that is, quote, made in pursuance of the Constitution. That's the language from Article 6. Customary law is not made in pursuance of or indeed with any regard to the Constitution. Third, the President has executive foreign affairs power as the constitutional representative of the United States in foreign affairs. But that general power is limited by the specific restriction of the Take Care Clause. That is, the Take Care Clause says that the President executes his foreign affairs power in accordance with the laws. Now, this reduces the question to, in my view, whether the laws in the Take Care Clause refers only to Article 6 law, that is, supreme law, or could it also include something else? Specifically, could it also include customary international law? That's the constitutional question that I think is posed. Now let me see how I can do on answering it. I think there are three reasons to think that the laws in the Take Care Clause includes customary law. First, the text doesn't exclude customary law, the text of the Take Care Clause. It doesn't tie to the kinds of law that's recited in Article 6, and indeed the Take Care Clause is not parallel to Article 6 at all. Article 6 recites specific categories of law, whereas the Take Care Clause refers only to, quote, the laws. Second, the status of customary international law at the time of the Constitution was that it was recognized as law generally applicable within the United States. During the Confederation period, there were incidents such as an assault on a French ambassador, and illegal seizure of ships that the constitutional generation thought should give rise to legal remedies. There were no federal enforcement mechanisms at that time, so it didn't give rise to any federal remedies. But the framers complained about this problem. Madison, in his Vices of the Confederation, specifically called out the inability to enforce the law of nations as a problem, as did Edmund Randolph in his opening speech at the Constitutional Convention. So they did think of customary international law as law, although they recognized difficulties in enforcing it. Moreover, and this is my third proposition, prominent members of the constitutional generation after the Constitution was ratified referred to customary international law as, quote, part of the law of the land, including Alexander Hamilton in his Pacificus essays, again, Edmund Randolph as Attorney General, and Attorney General Charles Lee. These were not specifically within the context of whether the president is bound by that law, but they were references that seemed to assume that customary international law, or the law of nations as they called it then, was part of the laws. And therefore, I think there is reasonably strong evidence, although I remain somewhat tentative on this proposition, that the reference to the laws in the Take Care Clause is broader than the Supremacy Clause, and specifically that it includes customary law as well. Now, let me quickly run through a couple of objections to this proposition. Number one, and you've heard this referenced by some earlier panelists, number one is the proposition that we need to be able to violate, we, the United States, need to be able to violate customary international law in the pursuance of our foreign relations. Indeed, many of the policy reasons that Professor Jinks advanced with respect to treaties don't apply, I think, to customary law, and the residual need to violate law that Professor Harrison referred to perhaps applies most strongly with respect to customary law. Nonetheless, I think that this question is answered by the Constitution when the Constitution says that the President must conduct foreign affairs in conformance with law. And I think the Constitution then assigns to Congress, not to the President, the decision whether to violate law, whether to violate statutory law, whether to violate treaty law, whether to violate customary law. Congress can override customary law or authorize the President to violate customary law, and indeed Congress has done that on a number of occasions. The second objection is that there is no direct evidence from the founding period that the President is bound by customary law. I agree with this proposition, but I also think there's no direct evidence the other way. So I think the references that I've quoted in which the framers seem to understand that customary law was part of the laws provide the strongest basis for reaching a conclusion on this. A third objection is that Congress has the power to define and punish offenses against the law of nations by the specific text of Article 1, Section 8. Perhaps this implies that customary law is not binding within the domestic legal system until it's incorporated by Congress through the Define and Punish Clause. I think this is a possible argument, but again, I think the Take Care Clause suggests that it is not a complete argument. I don't deny that Congress has the power to firm up customary law through its Article 1 powers, and indeed, when I get to the second part of my propositions, I think you'll see that there's an important role for Congress here, but I don't think that Congress's power to provide punishments for customary law undermines the separate obligation in Article 2 of the President to follow it. The final objection is that this would give, if you accept what I'm saying, this would perhaps give states, that is states of the United States, greater latitude to violate international law than the President, since I have said that customary law is not part of supreme law under Article 6, and yet is part of the take care obligations under Article 2. I think that is correct, and I think that arises from the fact that the framers were solicitous of state sovereignty, and at the same time were using the federal Constitution in particular to define the obligations of the federal government. I think the obligations of the states, and this is where Congress's power comes in, the obligations of the state to follow international law are policed by Congress through the Define and Punish Clause. So in that sense, the Constitution left international law, customary law, as, in a sense, non-self-executing on the states to be executed by Congress, but made it self-executing as against the President through the Take Care Clause. All right, now let me shift gears in the final part of my presentation, and having taken away with one hand I will now give back with the other. Although I think the President has an obligation to follow customary law through the Take Care Clause, I also think that the President should be accorded substantial and indeed almost complete deference with respect to the interpretation of customary law. The development of customary international law has both a communicative element and an active element, in the sense that it is developed by the actions of nations and by the statements of nations with respect to those actions. In the U.S. system, both of those are substantially under the control of the President. The President directs most of the United States' actions abroad, and the President is the sole channel of communication abroad. The President, through his executive power, is the constitutional representative of the United States in foreign affairs. And part of that authority is to make authoritative determinations of the United States' position with respect to the content of customary international law. For courts to make their own independent determination of the content of customary law would interfere with the President's authority to represent the United States on the world stage as to what customary law means. In a sense, then, the executive has a quasi-judicial role in elaborating customary law. So my final conclusion from that is that the oft-quoted case of the Pacatayabana is correct in both its senses. First, Pacatayabana says that customary international law is part of the laws of the United States. But second, it says that judicial enforcement of customary law is limited in the face of an official, authoritative executive act. And I believe that that is the correct conclusion. And as a result, I think that the rule that the President is bound by customary law doesn't pose the kind of structural problems for the exercise of foreign affairs that is commonly understood. The Constitution imposes on the executive branch a duty to take customary international law seriously, to reach good faith conclusions about what it requires. But it allows great latitude to the executive branch in reaching those conclusions, and doesn't ask that the courts second-guess disputed determinations of customary law. So to bring it back to the executive branch's torture memos, I think they were far too aggressive in asserting the President's authority in the face of customary law, but I think what they should have done was ask the President to take customary law seriously, and then ask the courts to take seriously and defer to the executive branch's determinations. Thank you.
I want to thank the four panelists for what I found to be very rich presentations, and also for being so good about keeping to their time. What we'll do now is I will give each of the four panelists about 2 minutes each to say any follow-up remarks they would like to make, in particular in responses to the other presentations they've heard. And that should leave us about a half an hour or so for questions from you all from the audience, and then we'll break at 10 o'clock. So, Ingrid?
Thanks for the rest of the panelists for very interesting observations. I guess I'd like to come back, given what everybody has said, to some of the questions I posed at the beginning, which is what all of this means for the appropriate role of the courts. That is, what are the courts to make of the various institutional issues that both John and Derek raised, and also with respect to Mike as well. I think for many of the reasons that have been put forward, both on abstract and specific levels, these are extraordinarily difficult issues for courts to deal with, and perhaps the answer for those of us who would like to see the administration take a different position or move in a different direction is to look more frequently to Congress and less frequently to courts. I do think there are a number of institutional constraints that have been raised in a variety of different ways that act on the courts in these contexts. So I'll stop there and leave it to the rest of the panelists.
Thank you, Kurt. Excuse me. Two thoughts. First, I want to disagree with Derek a little bit about the way the default should be set in the interpretation of treaties. I think that, if anything, it should be set the other way, that the president, rather than Congress, and it is of course a default, should have the authority to violate treaties on behalf of the United States. And Derek made a large contribution by pointing out that there are indeed situations in which it is in the interest of the United States to be able to bind itself, because the United States will sometimes find itself in situations where there are collective action problems among countries where they can get benefits from the cooperation. And the internal capacity that the United States and other countries with strong internal rule of law has is they are in the position in a situation like that of someone who is and is known to be religiously scrupulous, and who by an oath can make a credible commitment. The United States, in effect, is a country that can take an oath. Not all countries can. Not all countries have strong internal rule of law. But you don't take oaths casually. You take them only with serious reason. And sometimes, and to be a little more specific about that, sometimes there are situations in which the cooperative situation among countries is not a collective action problem, but is rather, say, a coordination situation, where all that's needed for the countries to act together and generate benefits from acting together is communication, that all they really need to know is to do the same thing, like driving on the same side of the road, games of coordination. Under those circumstances, no need for the United States to commit itself. What kind of situation the United States is in, well, we don't know, but there is sufficient need for flexibility that, as I say, I would suggest that although it's only a default, it should be regarded as being set the other way. I want to disagree with Mike Ramsey about the take care clause, and very, very briefly, because I think the implication of what he said, and in particular given the founding era people that he's cited, is that the president would then have a take care obligation with respect to all law, not only customary international law, which was part of law, but also state law and the law of foreign countries. And the parallelism I want to suggest that I think indicates why that's not right is that Article 2 begins, the executive power shall be vested in a president of the United States. It doesn't say the executive power of the United States, but it means the executive power of the United States and not, for example, the executive power of any state. The president doesn't have the executive power of New York. He has it only of the United States. Similarly, I think when the take care clause imposes on him the obligation to take care that the laws are faithfully executed, it's the laws of the United States. So he doesn't have that obligation with respect to the law of New York, just as he doesn't have the executive power of New York. He has the executive power and the take care obligation with respect to the laws of the United States.
And John's comments are well taken, and I should clarify just my position, just so that it might facilitate our discussion. I do think that there is a tremendous need for flexibility in the context of sort of allocating the authority to violate international law. We'll need flexibility to deal with the specific kinds of problems that might arise with respect to specific cases, and the global war on terrorism has demonstrated that in a dramatic way. I think to sort of salvage the idea that Congress ought to be the default, there are three kinds of ways in which flexibility can be preserved while still capturing the benefit of sort of providing a mechanism to make credible commitments. So first, there's the ex ante flexibility in the form of the international agreement that's concluded. So the United States, through the president, essentially the president, decides whether a particular agreement would be a sole executive agreement, a congressional executive agreement, or a treaty. All of those types of agreements are treaties within the meaning of international law, but not all of them are treaties within the meaning of U.S. law. Not all of them are Article 2 treaties. So as a consequence, this separate lawmaking procedure, this device, this mechanism for making credible commitments, can be preserved as a means by which we might make our intentions known to the world. Second, there's another ex ante way to preserve flexibility, and that is through the negotiation of the treaty itself. We can push for certain kinds of understandings. We can push for a broad right to terminate or suspend a treaty, or we could enter reservations, declarations, or understandings making clear that under certain kinds of circumstances we will abrogate our obligations under the treaty. Third, there's also the ex post flexibility of empowering Congress to delegate to the president the authority to decide specific kinds of questions. So the question, I think, for us to consider in deciding who ought to have this power is to decide whether those mechanisms of flexibility are sufficient to capture all the downsides of assigning to Congress the default while preserving the benefit of making credible commitments.
Quickly in response to John Harrison, I agree that the laws must mean the laws of the United States or the laws in the United States. I don't mean to suggest that the president would execute New York law or foreign law. I think just the question is, what does it mean to say laws of the United States or laws in the United States? And I think the fact that customary international law is a generally applicable law in the United States that was referred to as part of the law of the land by the framers brings it within that definition. But I don't mean to claim anything more than that. With respect to Derek Jinks's policy arguments, and I think this implicates then Ingrid's observations as well. If we're going to rely heavily on Congress to authorize the United States to violate its international obligations, and we're going to rely on the flexibility that provides for the system, we need not to erect interpretive rules that make it very hard to find that authorization. In other words, if we demand very clear statements so that courts can almost always find a lack of authorization, then we aren't leaving the kind of flexibility in the system that your policy arguments seem to assume that we need. And then I think that leads me then to two comments on the idea of using international law as an interpretive tool. I think that first, that does not solve a lot of the problems that we have been talking about. It changes the way we're approaching the question, but it doesn't change the question of, do we need to have the flexibility to violate international law, and is it problematic to make courts the primary repository of the question what international law means and how is it applied? And in particular, I would suggest with respect to Ingrid's presentation that courts in making the interpretive decisions need to be very deferential to the executive branch as to what customary law requires, or else you'll get into the same problems that I identified with respect to a direct application of customary law. That is, that the courts will take over from the executive branch the authority to speak for the United States as to the content of customary law.
Thank you for the follow-up comments. And we now have almost half an hour or so for questions from the audience. I understand that we have a couple of roving microphones, and so I will start taking questions. Look like there are a number of hands, which is great. Where are the microphones? I want to make sure people get those. Okay. This gentleman right here.
I'm Mark Weisberg,
Mark?
Law School, University of North Carolina. First, I'd like to thank the panel for an immensely stimulating discussion. You raised so many interesting points that figuring out exactly what I'm going to ask without taking up the entire half hour is difficult. But I will confine myself to two questions. First, for Professor Jinks, while my bottom line conclusion would agree with yours in the sense that I'm troubled by the notion that the president can violate treaties, it seems to me that the particular argument you make with reference to the importance of the involvement of the legislature would imply not only that the president cannot violate a treaty, but likewise cannot terminate the treaty, perhaps contrary to its terms, perhaps not, without the participation at least of 2/3 of the Senate. And that seems to me to be problematic. Second, to Professor Ramsey, one question I have with respect to your approach is that it seems almost to, as it were, invite the president to interpret customary international law in bad faith in order to avoid, quote, not breaking it, close quote, and then oblige the courts to go along with what might be a transparently bad faith interpretation of the law. And while there are other things I could say about that, that particular point seems to me to be problematic. Thank you.
Thank you.
Yeah, I do think that the policy arguments that I advanced support, although less so, support the idea that the Congress ought to also have, ought to be the default for terminating U.S. obligations in our treaty. I say less so, simply because I think it's a fair point to suggest that a treaty that allows a broad right of termination or suspension contemplates that in the executive function, in the process of implementing that treaty, states will have the broad right to terminate or suspend application of the treaty. That is to say, we might think that it's a classical executive function in the course of administering a regime that is unquestionably part of the law and administering that regime in a way that is consistent with the law to terminate the treaty. Nevertheless, we clearly elevate the transaction costs of terminating a treaty if we assign to Congress the power to decide whether or not the United States will terminate a treaty. So I'm acknowledging that that kind of argument lends some support. I just think that when viewed through the prism of what I think is a fairly clear allocation of authority in U.S. law, with the executive functions assigned to the president, that it makes sense to leave that authority with the president, or my provisional conclusion is to leave that authority with the president, irrespective of the fact that the policy argument suggests, even if less so, that Congress ought to play a role in that. I mean, and this is sort of an obvious point, that anytime you talk about raising transaction costs as a useful device for facilitating cooperation, you could say that if you push my argument to its logical extreme, we ought to have a rule in which every U.S. citizen must agree. Unanimity is required in order to make international law or break international law. But the point is sort of working within the framework of the way in which power is allocated in a general way in the constitutional structure, with this ambiguity, sort of how do we decide as a policy matter to assign the default? Makes sense to me in view of the policy argument to assign it to the Congress.
Yeah, thanks for your questions. If I could insert myself real quickly on the first question first. My view is that it's important to distinguish between withdrawing from a treaty in accordance with its terms and withdrawing from or violating a treaty not in accordance with its terms. The former, I believe, is a presidential power because it's part of the president's executive power to interact with foreign nations, and it does not violate the Take Care Clause because it's not a violation of the law. The president doesn't have a take care obligation there. In contrast, the second one is answered by the Take Care Clause. So that's where I would end up on that one. On the question of bad faith interpretation, I think that's a serious concern, and I don't mean to be inviting that. I think the president has a serious duty to interpret customary law in good faith, and if that emphasis didn't come out in my talk, I want to emphasize it here. The question is, what do you do about a bad faith? How to police a bad faith interpretation? It seems to me that there are, well, let me give you one way that I think is important, and then two follow-up avenues to go. The first step, I think, is that I would require, and I think Paquette-Diabana requires, and appropriately, a formal process of interpretation by the president. That is an authoritative act, not simply a position taken in litigation after the fact, but rather that the executive actually go through a quasi-judicial process of considering what the law requires. So a certain amount of formality before the courts would defer. Then, once you have that formality, I think there's two responses, and I'm not sure which one is best. One is to say that the courts would owe deference in almost all cases, but they would be permitted to find a bad faith interpretation if the international law was so clear that the president's interpretation simply couldn't be right. I think that wouldn't occur that often because international law is rarely so clear, but I can certainly imagine cases in which it could be. It makes me nervous to give the courts that authority, but perhaps it's a check. But another way to approach it, I think, is to say that the check against bad faith interpretation comes through the political process. Congress, I think, could use its impeachment power against a bad faith interpretation of international law, and the people could use their power of the ballot box against a bad faith interpretation. And indeed, I think you see the potential for this within the current war on terror, although we're for the most part talking about treaty obligations rather than customary obligations, but the question of whether the president has power to treat the detainees in the way that he is treating them has been argued by some people to be a bad faith interpretation of both the Geneva Conventions and of customary law. One solution to that would be to take it to the courts, but another solution to that would be to say, take it to Congress, take it to the ballot box, and see what result.
Over here. And somebody, the microphone, good.
I'm agreeing with Mark. My name is Catherine Admay, and I'm at the Public Policy School here at Duke. And I agree with Mark that you guys did a fabulous job. Thank you very much. I'm interested in changing the frame just a little bit of the question that you asked, which is the question you're dealing with is it, in what circumstances would it be constitutional to violate international law? And I'm interested in changing that to in what circumstances is it unconstitutional to follow international law, and particularly ask you as a panel to engage both with the Bolton argument that in general international law is unconstitutional, and with Scalia's recent dissent, which is in general we shouldn't be using international law or even foreign law as an interpretive tool for you, Ingrid. And my question is, do you as constitutional lawyers regard that kind of constitutional argument as being in bad faith, qua constitutional law?
Who would like to address that, Ingrid?
Yeah, I can start off with that. There's a lot in your question. I take part of it to be in Justice Scalia, his refusal to look at, I think foreign sources might be a fair way to characterize. Usually in a lot of those opinions, there's both things you could describe as comparative law, international sources that probably don't qualify as any formal type of international law, and then actually international law itself. I think for reasons that Mike has raised in some of his work, in other areas of constitutional interpretation, I think the use of foreign and comparative sources is very, very difficult. And I think it raises somewhat different questions in international law, and certainly international law in the context of the commander-in-chief power or the war powers. So to answer the specific question you posed, no, I don't think, personally, I don't know Justice Scalia, so it's hard for me to opine on whether he's acting in good faith or bad faith, but just on the face of the opinion, I think there are difficult problems with using comparative sources. at least I find them difficult. I personally find it very difficult when we start talking about European nations or civilized nations. There seems to be a quick move sometimes to assume that we know who we mean when we want to look abroad at foreign sources. So that's something that personally makes me uncomfortable, as big a fan as I am of using comparative, and international sources. When is it unconstitutional to follow international law? That's a huge question, and I think on this panel, we've been thinking at least of customary international law and treaties as they are binding on the United States. I mean, there's a huge body of international law and international norms out there. What the European Court of Human Rights does, for example, that aren't even arguably binding on the U.S. And it may be if we sought to conform our behavior to some extent with some of those decisions, we might run afoul of other provisions in our own Constitution of the Bill of Rights and so on. And I think it's relatively clear that after Reed versus Covert, that in terms of the Bill of Rights norms themselves, we can't bargain around those through the treaty process. I hope that gets at your question. I'd love to use this opportunity to weigh in on a whole bunch of other things that have been said on the panel, particularly some of the things that Mike has said about my own work. But I'm going to actually use it to direct a question to Derek very quickly that's on the topic, I think, that has been raised. Derek, can you, and this is really a question, I don't have an agenda with this, I don't know the answer to it, but it seems to me the payoff to your approach is one that we would have to look at almost empirically. I mean, that is, your claim is that we will do better out there because nations will want to bargain with us, will want to enter into commitments with us if we limit the way in which treaties can be violated and get Congress involved. And I guess one question is whether there's any real way of measuring that empirically, and as a related question, whether there are good measures of, for example, I think the decision to use a treaty or a sole executive agreement, although different, I would be wondering if there's empirical evidence that that decision somehow influences how willing folks are to bargain with us, because people have been focusing on the cost side, but I think you might want to say something about how certain we are on the payoff side.
Yeah, just to respond to this quickly, there are two points I would make. First is, I think there's an aspect of the argument that we can talk about sensibly without reference to empirical evidence. So you could say that there's a formal claim, and just a fairly straightforward formal claim about the institutional features of the president and the Congress and the value of transaction costs in achieving cooperation in the absence of some centralized authority. Typically, formal models of contracting as a device to overcome collective action models just simply work with the assumption that the parties can make appeal to the government to settle their dispute at some point. There's this background assumption of enforcement, and of course, in the context of international law, you simply can't make that assumption. What ought that feature of international law do to the formal modeling of solutions to collective action problems? So that's point number one. Point number two is that there actually is some empirical evidence. One example is the recent book by Lisa Martin from Harvard on democratic commitment. She sort of starts with a point that I think is a provocative point, that our assumption might be that democracies have a problem making credible commitments on the international plane because democracies are fickle and individual governments cannot make representations on behalf of their populace in many respects because the citizenry may change their minds. There's reasonably quick turnover in democracies. We might suspect that the difficulties of democracies making credible commitments would actually translate into, in some concrete way, translate into problems that democracies have on the international plane of negotiating treaties in which they get substantial concessions from their treaty partners. And as she looks at the evidence, she actually discovers that the opposite is true. Democracies actually seem to do better on the international plane in getting concessions from their treaty partners. Democracies seem to be able to make credible commitments in a way that non-democracies cannot. And she sort of speculates why that might be, and she draws on this theoretical literature suggesting that an institutionalized legislative participation actually increases the credibility of commitments as one unifying conjecture that explains the evidence. But there is at least some empirical record that's built that would support the idea that, for all the reasons that democracies do better on the international plane in achieving the benefits of international law, we ought to think about what it is about democracies that enables them to do that.
If I could intervene real quickly on that, I think that the exchange you've heard illustrates the difficulty of doing constitutional law by policy analysis. And I would suggest that the Constitution makes this decision for us, at least with respect to treaties in most cases, by making treaties part of the supreme law of the land and assigning treaties to the judicial branch through the mechanism of Article 3. There's not a comparable assignment of customary law to the judicial branch in Article 3, and therefore I see a difference between those two, and it's a decision the framers made for us, and if we don't like it, we can change it. But to go back to the question real quickly, I think, because I think we got away from the question a little bit.
It's entirely my fault.
I think, although I don't really, I pretty much agree with what Ingrid said about it. I think it's important to note or to bracket that when we're talking about following international law either through treaties or customary law, that neither overrides the Constitution with respect to our domestic law. That if the Constitution puts us in violation of international law, or the Constitution prevents us from following international law, so be it, and we have to either make the violation or amend the Constitution. So I think all of my comments, at least, are bracketed by the idea that neither a treaty nor customary law can compel us to violate the Constitution.
Over here.
Marty Lederman. Thanks for a very provocative and interesting panel. I think it's uncontroversial that the United States can violate a treaty provision simply through the enactment of a later enacted statute that might trump the treaty, because both are forms of supreme law under Article 6. And I understood the question that may thread through all of your comments to be whether the president can unilaterally, through his foreign affairs or commander-in-chief power, violate a treaty. And I think that's become an issue because of a couple DOJ documents. Interestingly, the administration has not claimed this power yet. It has backed away from it. But in the Bybee memo in January 2002, there's the assertion that the president could have decided simply we will suspend Geneva as to Afghanistan if we want to, a power that John Yoo in a subsequent memo said was simply at the president's discretion under his commander-in-chief power. And then in the brief in Medellin, there's a sentence in which the brief says the president could, here we are not going to violate the UN Charter by ignoring the ICJ judgments, but the president could decide that the United States will violate the Charter. It's a little cryptic as to whether that's a constitutional claim or whether the Charter itself allows a violation. But they've backed away from it, and I didn't hear anything, I think, from any of the panelists that would support that argument, with the possible exception of John, and I'm not sure. John seemed to be suggesting that if a treaty is a supreme law of the land, the president may not unilaterally decide we won't abide by it, but there's some forms of treaty obligations that are not. Am I getting it completely wrong?
John?
Treaties may but need not create U.S. domestic law consequences. They may create only international law consequences. And because they need not create U.S. domestic law consequences, they need not impose the take care type obligation on the president. I think the Charter is a fine candidate for a treaty that doesn't automatically create U.S. domestic law consequences. And indeed, this is something I learned by accident recently, and it's interesting in the Medellin context. The UN Participation Act authorizes the president, when the Security Council imposes sanctions, to implement the sanctions for U.S. domestic law purposes. But there is that circuit breaker there. It takes the separate action by the president to make the sanctions effective in the United States. They're not automatically effective. The president is claiming a similar power with respect to ICJ decisions, I think, in Medellin that he doesn't have on a statutory basis, which is interesting. But the Participation Act is set up that way, I think, on the assumption that the charter isn't self-executing the extent that it doesn't pass through Security Council resolutions, even though Security Council resolutions are binding on all members, all parties to the charter.
So is anyone supporting the administration's proposition in these documents? Take something that we all agree would be an Article 6 treaty, a supreme law of the land treaty provision.
Like the charter. Yeah.
That is self-executing.
I think
Okay.
it's not, right? Yeah. That's,
That does impose some obligation in the same way that a statute imposes a take-care obligation. Do we think that, does any of you think that the president has the power to decide the United States will not abide by a treaty provision in any way that, in any circumstance in which he could not, say, trump a statutory obligation? I didn't hear anyone defending the administration's.
I think we only have one candidate. Right?
Yeah, I say no. I think there are specific situations in which the president is not bound by a treaty. One is if the treaty is non-self-executing. I agree with John on that. And another is if the treaty is unconstitutional. And a treaty may be unconstitutional if it unduly restricts the president's commander-in-chief power. For example, a treaty could not divest the president of command of the U.S. forces. And I would think the president would not be obligated to follow that treaty. But in neither respect is that different from a statute. The president's not bound by a purely hortatory or aspirational statute. It's not bound by an unconstitutional statute. As you say, the DOJ memoranda didn't make specific claims like that, but asserted a blanket authority to suspend. And I'm on the record as saying I don't agree with that.
Okay, let's move on to another question. Over here.
I hate to do this, but it's sort of the same question. Jennifer Elzey, Congressional Research Service. Going back to the Medellin case, I read the government's brief as asserting that it's not the law of the land. The ICJ decision is not the law, but that the president can implement it if he wants. And my question is, can he then override statutes that might stand in the way, or take some other power that he wouldn't ordinarily have to enforce such a decision? In other words, it's not that it's unconstitutional. The treaty is not unconstitutional, but it involves which branch would be the one ordinarily to carry out the requirements.
Let me just, so in case some people in the audience aren't familiar with the Medellin litigation, which the last two questioners referred to, this is a case pending before the Supreme Court at the moment. The background is that the International Court of Justice, which sits in The Hague, issued a decision last spring ordering the United States to conduct review and reconsideration of about 49 death penalty sentences in the state court level throughout the United States. So there is an obligation right now in the United States to give hearings, at least, to certain individuals who've been sentenced to the death penalty, even though a number of them have been beyond the point at which that usually they could get a further hearing. They're in habeas corpus review, for example. And the case before the Supreme Court is an effort by one of those Mexican citizens to get the benefit of this international court decision, get a hearing ordered in his case. And the government's position is that the decision of the International Court is not itself law of the United States, doesn't have any operative effect. And the executive has also disagreed with the reasoning of the International Court about the treaty obligations imposing this hearing requirement. But, as the last questioner just mentioned, has said that the executive has decided through a memorandum from the president to, in effect, implement the International Court's decision by requiring the state courts to give the hearings after all. And there are good questions, in this case, not about violating international law, about which institutions can be the implementation for complying with and implementing obligations the U.S. has. Anybody on the panel want to address that additional issue? Don?
Yeah, I'm gonna follow through on what I said about the way in which the president in Medellin is saying he's got under the ICJ statute a power similar to his explicit power under the UN Participation Act, and say that if that is true, then there probably are situations in which the president's implementation could certainly override state laws. I mean, that's sort of part of the claim there, and override federal law in the following sense. For example, rights created under federal statute can be subject to sanctions imposed by the president pursuant to Security Council resolution and the UN Participation Act, I think, not because of any special foreign affairs power in the president, but because when you've got two conflicting sources of federal law, you have to reconcile them. Sometimes, for example, the more specific controls the more general. There are other similar principles that can be used to reconcile them. Under those principles, I suspect that, that sometimes, if it's true that the president's got the power he's claiming in Medellin, that it would result in particular cases in overriding what would otherwise be the consequence of federal statute. Sort of continue with my general theme, I think you would decide those questions the way you would decide other questions of conflicting sources of law that operate sort of at the same hierarchical level, two different statutes, for example.
Okay, other thoughts from the panel? Okay, I think we can do one more question. Yeah. Let's make sure the microphone. Thank you.
Hi, my name's Ben Davis, University of Toledo College of Law. My question goes another way, is looking at all this from the point of view of somebody who's overseas, either one of any other nation in the world. If they look at what I'm understanding from what you're saying is that between the president, between the legislative, and between the judiciary, there are possible situations where the president or any one of those can go ahead and violate international law, and that there may be constitutionally permissible grounds that it's the president, but from the point of view of somebody from another country, one of the states that's also subject to international law, or the treaty or customary international law, that's a violation of international law, and whoever does it is engaging international responsibility of the United States vis-a-vis all the other countries in the world. That may be civil responsibility, or it could be international criminal responsibility. So when you look at this question of who in the constitutional structure is going to be able to violate international law, I wonder to what extent you're overlooking the consequence of violation, which is this engagement of international responsibility. And does that at all alter adjust the way that you look at these issues of bad faith interpretations, the issues of possibly even criminal acts at the highest levels of civilian authority?
Thank you. Anybody want to address that?
Yeah, at least for me, I think it's a terrifically important question, and there's no doubt whatsoever that if an institution of the United States engages in some, as a matter of domestic law, lawful act that has the effect of violating some international legal obligation, then the U.S. has to face whatever consequences issue from that violation on the international plane. The question, it seems to me, is who gets to decide whether, in a particular case, it's worth suffering those consequences for whatever benefit we expect to issue from violating the law, just in the same way that a private citizen, an individual might decide to violate the law, and face the consequences of violating the law, but it may well be worth it to them under the circumstances. So I think that even if you take that point as seriously as we can take it, and I take it very seriously, I'm not sure that it helps us address who ought to get to decide without looking at the various institutional features of the branches of government in the United States.
John?
Yeah, just very briefly. In fact, I think that the framers specifically contemplated that the international law consequences of international law violation by the United States could in turn create domestic political incentives for U.S. actors either to conform with or violate, but often to conform with international law. I think that's absolutely right. But I think the existence of those political incentives is just one part of the story, the kind of story that Derek in particular has been talking about. But it is absolutely there.
I want to thanks again to the panelists for a terrific job. We have a keynote address at 10:15, so we would ask you to take a short break, but please do be back in your seats by 10:15. Thank you.